Joining us now in studio to offer some legal insight into the court proceedings is criminal defence attorney and legal analyst Jami Floyd. Jami, good afternoon again. Strauss-Kahn's lawyers yesterday hinted at a possible consent defence, that this wasn't something that was forcible. But the lawyer for the victim has been absolutely adamant that his client absolutely did not agree to any kind of sexual activity. So are we now talking about a his against her battle in court? Is that what this is?
What Brofman said was that the forensic evidence, as far as he's seen it thus far, is not necessarily consistent or only consistent with a forcible encounter. So that might mean, and most likely means in these kinds of cases, a very ugly he said, she said kind of case, where the defense goes about digging up and sullying the victim, and the victim who, despite all the efforts of law enforcement and the media to protect her identity, it eventually comes out, and she does ultimately have to testify. And we hear, as we already have, all about the alleged perpetrator's background, etc. So that ultimately generally becomes the case. But it could also be a defense of some sort of consensual activity where perhaps he says he paid for sex, or he was set up, as the French seem to believe, up to 70% of them thinking it was some sort of conspiracy where the DNA was somehow planted, or perhaps she exposed herself. I mean, they can come up with any kind of theory. It's very early in the case, and we do have to try to maintain some sort of presumption of innocence. It's early in the case, as I've said, and anything can happen in these kinds of cases. I'll remind you of the Duke Lacrosse case, a similar kind of case.
Indeed. Now, Strauss-Kahn has been on the front page, I understand, of virtually every newspaper apart from in South Africa. So is it possible that he could claim that he can't get a fair trial in these proceedings, and therefore the whole case should be dropped on those grounds?
So when you say every paper, you mean every paper in the world?
I do. I mean every paper in the world.
Well, that's quite amazing, because we talk about a fair trial somewhere in the United States, and usually we mean somewhere in the state where the action occurred, because when you talk about a change of venue, you can't even change states. You can only change to another county in the state where the action occurred. Look, these kinds of prejudicial pretrial publicity cases go back to our founding with the Aaron Burr trial. Think about Fatty Arbuckle. I mentioned the Duke Lacrosse case. But someone who can match the state witness for witness, expert for expert, lawyer for lawyer, someone with the kind of resources like Mr. Strauss-Kahn, he has a better chance than the average defendant. I mentioned O.J. Simpson, for example. So perhaps he has a better shot at overcoming the prejudicial pretrial publicity.
Jami Floyd, thanks so much.